On request made on behalf of Mr. T.J. Mahanda, Learned Senior Counsel, appearing for the appellant, list the matter after 1 week.
Right, please, Lordship.
Hmm.
I'd like to mention item number 5. Would you consider the other side?
Have you given your mention slip?
Yes, I have given already.
Lord.
Item 5.
Okay, yes,
Can we
please.
be after vacation, due vacation, Lordship, the engaged council on it appearing from SK Nargis on behalf of SK Nargis.
On request made on behalf of MS SK
Can we-
Nargis, Learned Counsel,
After
for the
vacation also.
appellant, list the matter after
Vacation, Lordship.
the Bihu vacation.
Deeply obliged.
Item 1 of daily leave admission.
Jail
Bail
appeal.
appeal is for the first time.
We'll let the registry appoint amicus
Yes.
curiae, yeah,
No, that can be done.
okay. This is an appeal from jail. Stop. Admit. Call for the LCS. MSS Jahan, the additional PP. Appears on behalf of the state respondent. Informant. Oh, this
Not-
is an appeal from jail.
And not made a party, but
Now, how do we go about this? Okay,
without the LCR, it will be difficult to find
yeah,
out,
it will be.
even in.
Registry is also directed to appoint an amicus curiae from the panel of list from the empaneled members of the learned advocates as amicus curiae. List after 6 weeks.
After receipt of LCR,
Yeah,
2
After-
will also be the same. Item
two
2.
also same thing. Same order.
Item 3, order.
Paper book is ready.
May please, Your Lordship. It's for the paper book.
Have you received the paper?
No.
That is why 3 numbers of paper book is shown in the.
You have
column.
received?
Yes, I have received.
Okay. Registry is directed to furnish a copy of the paper book to the learned counsel appearing for the appellant. So, list the matter for hearing after
4 weeks.
4 weeks.
Obliged.
Item 4,
I
May
think
please.
no paper book is ready, but I is pending, no?
I is pending.
IAS
I have
for
for suspension of the sentence, Lordship. Lordship, if I take your Lordship to the paper book,
Hmm.
the FIR at page,
just a minute.
Lordship. Yes, FIR is at page 4 of the paper book. FIR dated 7/3/14.
Are you pressing the IAS at this stage?
Yes, Lord.
Or can we have hear the matter?
I'm pressing the IL also because there are material contradiction in the.
What do you say, Jahan?
Up to your Lordship, otherwise
We can hear the
No,
main
because-
appeal.
paper book is ready.
Paper
so
book is ready otherwise.
Can
Then
be
we can
done.
hear the main appeal.
Lordship, yes, yes, Lord.
Okay. Have you received copies of the
Yes, yes,
paper
yes.
book? Parties have received the paper book. Stop. List the matter for hearing. In a short period.
Lordship, Lordship. Because there are, I think, I will show Lordship, there are material contradictions in the evidence of the.
How many,
PWS.
how weeks do you want? After 2 weeks, 3 weeks, 4
After 2
weeks?
weeks, Lordship.
Otherwise, it's a 22 matter. It's a new matter.
The
There are
problem he's got is IA,
lot, it's
Yes,
2 weeks.
2 weeks.
all right.
Six,
Please, your lordship,
Mm.
this is appeal,
Judgment and order against the judgment order dated 27/9/2022.
1 minute.
Convicting rigorous imprisonment for life.
LCRs have been received.
LCR was called for. LCR received an office note.
LCR is here.
LCRs come.
I'm updating this. Update. Our update. We are
Let's-
yet to
there
file
is
our objection to the IA, Lordship. Today it has come up for the first time.
Okay, in the main criminal appeal. Heard Mr.
B. Buragohai.
B. Buragohan and the counsel for the appellant. Also heard MSS Jahan and the additional PP Assam. Stop. LCRs have been received. Registry is directed to prepare the paper book and list the matter up to 4 weeks. In the IA, heard Mr. B. Buragohan and the counsel for the applicant. Will issue notice then?
Lordship.
Issue notice.
Notices were already issued, I think.
No, first time coming.
Oh, first time.
Oh. MSS Jahan and its additional PP. Assam appears on behalf of the respond number 1. Stop. Respond number 2. You'll have to take steps.
Yes, I have taken a step.
You have taken steps.
Yes.
How?
In the appeal.
In the appeal, ma'am.
In the appeal.
In the appeal, I have
Okay,
taken steps.
Okay, you have taken. Okay. How much time do you require?
I'll require 2 weeks time to file my affidavit.
MSS
object.
Jahan, Leonard counsel for the Leonard additional PP. It's about 2 weeks time to file objections. List after 4 weeks.
Lordship.
Obliged. I love it.
seven,
May I please, your lordship, lordship, in this matter, we have filed our affidavit
Affidavit with regard to
with regard to the objection filed by the respondent.
It's not required actually, the criminal appeal. It's not a repetition.
criminal appeal. In the
Yes, Lord-
criminal appeal
Yes, lordship.
or in the IA.
Is.
Against the I, we have filed an objection.
Exactly. It has to be like that. So you file your reply also.
Yes, lordship.
What is this IA?
I
Bail.
for suspension of sentence. Lordship, since the LCR has arrived here, Lordship,
Yeah,
can the registry be directed to prepare the paper book?
in the main appeal.
Yes, ma'am.
Heard MS,
Yunanda.
Nanda, Leonard counsel for the appellant. Also heard MS, B. Boyan, Leonard additional PP Assam. LCRs have been received. Registry is directed to prepare the paper book and list the matter after 4 weeks.
Okay, lordship.
eight,
Eight also we have filed an objection, you know.
In the IA.
Yes, lordship.
Oh,
And in the main appeal,
Main appeal, LCR has arrived, you know.
paper book is not ready.
Not ready.
Heard MS,
Yunanda.
Nanda, Leonard counsel for the appellant in the appeal. Also heard MS, B. Boyan, Leonard additional PP Assam. Start. List this matter.
After preparation of paper.
Preparation of the paper book.
Lordship, date may be given.
That will be,
cannot be
how can I
given,
give a
yes.
date? They'll have lots, they have. Let it come out of the preparation of the book.
Here,
Obliged.
oh, supplementary. notes.
Fourteen of supplementary list. Order.
May I please your lordship? Also kindly matter me taken up after some time. Also D. Borgohain is appearing in this case. Lordship. After some time, lordship.
This is a new I. In the earlier I, which was rejected, I had filed my objection. This is the second I
Second,
Second,
for
lordship,
suspension and bail.
regarding bail.
Then we'll issue notice.
Chip, in fact, my earlier objection would do because this is
It's on the same ground.
almost on the same ground.
Lordship, new ground has come, lordship.
How,
That
We have filed a new ground, lordship.
what is your new ground?
New ground is lordship. Petitioner son is already studying class 10 in Don Bosco School in Dimapur, lordship. Lordship, he has faced some financial difficulties, lordship. That's why we have filed this petition regarding bail.
that is the personal issue.
So kindly, after some time, lordship, brief is not with me, lordship.
Okay, after some time.
Borgohain company.
Nine of daily list hearing.
May it please your lordship. Lordship, today I'm seeking for an adjournment. Lordship, Amicus Security Mr. K. Goswami is not well. I've informed.
Yes, he informed me in the morning he has some shoulder pain. So he's taking rest. He informed me in the morning.
Monday or Tuesday, whichever is convenient, Lordship.
It is submitted that the learned amicus curiae is in this post. Stop. Third MS Jahan, learned additional PP for Assam. Release the matter after 1 week.
Oblige me.
Then.
Two 2018 matter.
Then your lordship, paper book is not ready as part of cost list, mine. It's not reflected,
No, paper book is ready.
but it's not written and we have not received a copy of the paper book. In the cause list also, it's not reflected, my lord.
Paper book is ready.
BBC.
Paper book is ready. None appears for the applicant. Paper book is ready. Registrar is directed to furnish copies of the paper book to learned counsel for the respective parties. And list the matter after. You want some time?
Lordship, after 2 weeks.
To 3 weeks.
Right.
Hmm.
Well,
May please your lordship kindly adjourn for the day matter, lordship.
Why?
Lordship, my senior has some difficulty today, lordship.
Who's your senior?
Mr. D. Talukdar, lordship. Kindly for today, lordship.
I have prepared it. They have a personal difficulty.
You could have informed
Informed.
her. There's already a notification that you
Yes, my
should
lord.
give your.
Hmm.
Okay.
Lordship, today,
Lordship,
lordship. kindly.
coming week
Next.
or after Bihu.
Her MS B. Buyan and it's additional PPR sum. On request made on behalf of Mr. D. Talukdar, the counsel for the appellant. List the matter after
Bihu vacation.
After Bihu vacation.
the bill vacation.
Oblige.
Today also we are raising earlier.
No, one more matter is there. Lordship 13 is there. I've
13.
seen my learned friend.
You can start, please.
It's just.
Here 15 witnesses. Puri balo? Sorry. No, no, more Puri.
May I
Yes,
please,
please.
Lordship? The appellant has been convicted for the offense under section 302 IPC.
Huh?
302.
302.
Originally, there were 3 accused persons who have been acquitted. Allegation is he has killed his wife. This is the last. May I please take a look at the FIR first? Yeah. Page 4. May I please read, Lordship? It is Exhibit 1. FIR is dated 2/7/2014. Sir, humble submission is that on 1/7/2014, there was a quarrel between husband and wife in the house of Bijit Shaikia, alias Ken, a resident of Lahing village, and following that quarrel, Bijit Shaikia killed his own wife by assaulting her repeatedly. Thereafter, the dead body was cremated inside the compound in presence of a few persons of Lahing village. I learned about the entire incident from Sri Soni Kachari, a resident of the said village, and I informed the police about the same.
Who is this informant?
He is Deven Gogoi, PW1.
VDP secretary.
PW1. VDP secretary is. Here, I beg to point out one thing, Lordship. His information is based on one Soni Kachari. That Soni Kachari has not been examined as witness. He is a hearsay. So PW1, his deposition at page 10. Says, I do not know the accused persons who were present in the dock of the court today. I am the VDP secretary of the locality. I am original resident of Shivsagar district. I am living at Hatipoti, Sukafanagar, Moriani since the year 1980. The incident occurred less than a year ago. On the date of incident, I was present at my home at about 6 p.m. while I was tying my cows in the cow shed. At that time, one Phoni Kachari, a resident of Lahing Gao, came to my house and shouted from outside that accused Ken Shaikia, alias Vijit Shaikia, had assaulted his wife with dao blows, thereafter committed murder of his wife and hanged her in his house. Hearing the incident, I immediately went to Mariani PS and informed the matter to police. I did not visit the house of accused Ken Shaikia, alias Vijit Shaikia. I lodged Ejaar before police, which was written by one person named Muhammad Jamal Ahmed, who after writing the same, read over it to me, and thereafter I put my signature in the Ejaar. Exhibit 1 is the Ejaar, and Exhibit 1(1) is my signature thereon. Cross-examination. Police examined me. I do not know who cremated the body of the wife of accused Ken Shaikia, alias Bijit Shaikia. The Ejaar was written by the scribe as per my version. I do not know under what circumstances the incident took place. He is a hearsay evidence totally. Now PW2, Lordship. He is a video camera operator. Police took him to the place of occurrence. page 12. On 1/7/2014, police requested me to visit the house of accused Ken Shekia alias Bijit Shekia. As per direction of police, I went to the house of accused and thereafter took video footage of one Meet Dao and wearing apparels, garments which were seized by police in my presence. My Sony camera, DVD writer, and all other necessary equipments were seized by the police by its serial list Exhibit 2, where Exhibit 2(1) is my signature. Cross-examination. Police examined me. I have not seen the video apparatus in the court today. I also do not know anything about the occurrence. The original hard disk of my camera has not been submitted by me to the police in connection with this case. I have photographed the dead body, which was kept concealed in the earth, and I also recorded the statement of witnesses. I do not know whether the same were the hard disk or memory card of my camera. After taking video footage, I have deleted the same after giving the copy to police in the CD. Now, Exhibit 2, Lordship, is at page 84. May kindly take a look at that.
Yes.
Page 84 starts and particulars is page 85. One Sony camera, HD video camera, one DVD or PRO, one pack 4.7 GB, such and such compatible Mozart player. These were not exhibited in the case. So these were not before the court. So what he has videographed or what are the video footage, etc. These are not there. So these witnesses also have no help. Now, in this case, there are two child witnesses, like the sons of the deceased as well as the accused person. This is PW3 and PW6. Now PW3 was page 14. Lanet trial court first examined him to ascertain his competency and thereafter recorded the evidence. Being satisfied that he is able to testify. And it is recorded at page 15. By putting the above questions, I am satisfied that she will be in a position to give rational answers to the questions put by the prosecution during her examination. And I know accused Bijit Shekia, who is present in the chamber of the court today. He is my father. This is Dipali Shekia, was my mother. My mother was in the habit of consuming alcohol. On the relevant day, my mother chased all of us from our residence, and thereafter she committed suicide by hanging herself. At present, I am staying along with my father. He is taking care and custody of my health and education. At the relevant time, I was present in the Namghar. When I returned back home, I noticed cut injury on the body of my mother. My parents used to quarrel amongst themselves on petty matters. My father is also an alcoholic person. On the relevant day, my father was not present in our house as he came out of the house for his daily works. I did not witness the incident of hanging as well as receiving cut injury by my mother. On seeing the injury on the day of my mother, I cried for help. I shouted for help to my father. After the incident, police arrived at our residence. I was produced before the landed magistrate by police for recording of my statement. Exhibit 3 is my relevant statement, wherein Exhibit 3(1) is my signature. Now, his 164 statement is little different, almost different. There he implicated. But here, the prosecution has not declared he was hostile and bring the contradiction, did not prove the contradiction of 164. So 164 is not there because 164 statement is a substantive piece of evidence. It is a previous statement. It is to be contradicted if there is a contradiction. Now, similar is the case of PW36 also. PW6 also. PW6 is his brother. PW6 Lordship will find at page 21. page 21 and 22.
Oh.
Here is Ritu Shoikia. Master Ritu Shoikia. They are also same as Petra. By putting the above question, I am satisfied that she will be in a position to give rational answers to the questions put by the prosecution during her examination. I know the accused Bijis Shoikia, who is present in the chamber of the court today. He is my father. Sri Ratul Shoikia is my brother. I was produced by police before the magistrate for recording my statement under section 164 CRPC at Titawur Court. Exhibit 8 is my statement recorded by the magistrate, while in exhibit 8.1 is my signature. This is Dipali Shoikia was my mother. At the time of incident, I was studying in class 7. The incident occurred in the day hours. On the relevant day, my father, Bijis Shoikia accused, went out of the house to his workplace. Thereafter, in absence of my father, my mother committed suicide by hanging herself. At present, I am staying along with my father. He is taking care and custody of my health and education. I gave statement before the magistrate voluntarily. Nobody tutored me to give statement before the magistrate. But here also, what statement was made before the magistrate has not been brought. Mere exhibiting 164 statement is not enough to prove the previous statement. It is because she did not depose whatever she stated before the magistrate in the court. So if there is any contradiction or he was not, she or she was not supporting the prosecution case as per 164, it was the duty of the prosecutor to declare him or her hostile and bring those contradiction on record. And thereafter, at the time of examining IO, confronting them with the same things with the IO and take the corroboration. These are absent. So what remains? Their deposition before the court. Now, if I may take your lordship to the part of the judgment where these have been dealt with by the learned trial court. Learned trial court did not believe what has been deposed before in the court, but make reference of the 164 statements.
Where is the order?
Judgments, lordship, judgments starts from page 57. And page 77, 78. PW 3 and 6 has been paragraph 33.
Paragraph
33, page 78. Coming back to the evidence of PW3 and PW6, who are the sons of accused Bijis Shoikia, alias Can, as well as deceased Dipali Shoikia, it would transpire that both of them are inconsistent witnesses. At first, Sri Ratul Shoikia, PW3, stated before the learned magistrate in his statement under section 164 CRPC that on the relevant day, his father, that is accused Bijis Shoikia, alias Can, quarreled with his mother, Dipali Shoikia, and thereafter accused Bijis Shoikia, alias Can, assaulted his wife with a dao on her hand, for which the bone of the hand of her mother came out. His mother fell down on the ground, and his father was sitting nearby the body of his mother. And at that time, he was uttering some words. Noticing his mother on the ground, he cried for help, and nearby people gathered at their house. He proved his signatures by the exhibit 3.1 on the statement, and also the statement by the exhibit 3. Witness Ritu Shoikia, PW6, during his statement before the learned magistrate under section 164 CRPC, stated on the date of incident, he witnessed his father assaulting his mother, Dipali Shoikia, with a lathi, and thereafter with a dao on her hand, for which his mother fell down on the ground. After some time, his father, Bijis Shoikia, alias Can, hanged the body of his mother, Dipali Shoikia, with the help of a chadar in the room. He witnessed the incident of hanging of his mother by his father, Vijay Sikya, alias Ken, and he shouted for help. At that time, nearby people gathered at the house. Sometime later, police also arrived at the house. He categorically deposed that he had witnessed the whole incident through his own eyes. But during evidence before this court, both these two child witnesses told a different story by telling that deceased committed suicide and accused Vijay Sikya was not present at the relevant time. Paragraph 34. A child witness is a very sensitive witness. He is immature and in many cases may be subjected to tutoring. He is susceptible to threatening to change his versions, and as such, his evidence is required to be scrutinized very carefully. PW3 and PW6 had completely changed their version and narrated a new story. Although the prosecution tried to establish that, they stated before police as well as the learned magistrate that his father committed the murder of his mother. However, the witness admitted of deposing as such during his evidence, and he also assigned the reasons thereof. It is apparent from the evidence of sons of deceased that at the time of his adducing evidence in the court, they were staying with his father, accused Vijay Sikya. Under the circumstances, this court is of the view that they have been tutored subsequently as he is with his father. Naturally, a motherless child of 12 years or 13 years would do and say exactly how he tutored to save the skin of his only hope and support with whom he had been constantly staying, and it becomes more natural when the person is his natural father. Therefore, this court is of the view that this witness 3 and 6 cannot be relied entirely. However, the part of his evidence to the effect that on the particular day of occurrence, his father and mother had a quarrel is taken into account as the same is corroborated by their earlier version, and the prosecution has been able to prove his circumstances against the accused, Vijay Sikya. Now, selectively, it cannot be done. 164 CRPC statement was not brought, only it is exhibited. It was not brought on evidence. Now, learned court below on its own motion take contradiction from there. Whereas prosecution did not bring the prosecution declaring hostile or whatever this. 164 statement is not a substantive piece of evidence and it cannot be dealt like the manner learned trial court dealt with. Either, yes, learned trial court could can disbelieve the story of a child witness before the court. He was with father, etc., but cannot bring those to prove corroboration, whatever is state corroboration of the 164 statement. This part is my humble submission. It is not legally tenable. Whether he is those witnesses, whatever they have deposed before the court is to be believed or not, it is different thing. It is altogether different things that or the evidence of how to deal with the evidence of child witness as per law, it has to be followed.
You have any authorities on that?
Yes, authority, some portion of his is correct that they were with their father. There is a probability. He can disbelieve them, but cannot take a corroboration from the 164 statement, which was not corroborated by in his evidence by the prosecution. It is not only the duty of the prosecutor, it is the duty. Trial court also should have been circumspect while recording the statements of child witnesses, because they have exhibited 164 statement. It is also a subtle law that mere exhibiting a document is not sufficient. And 164 is not which is a previous statement. It is not treated as a document like confession. It is a different. So trial court could not have brought all those things from his 164 statement to record and take corroboration from there. What suited for the court to convict him. I will submit some decision later on, Lordship. Now facts and by points. Now PW 4. It's page 17, page 17. He says, I know accused persons named Sri Gulab Gogoi and Sri Gonoram Borua, who were present in the chamber of the court today. I have met accused Sri Bijit Shrikia on the date of incident in the Moriani PS. I am the VDB secretary of Katonibari Tea Estate on the relevant day. I went to Moriani PS for some personal work. There I noticed the accused being interrogated by police. Police requested me to accompany them to the house of the accused. At that time, accused Sri Bijit Shrikia also accompanied police to his house. I noticed smoke in the house compound of the accused. I came to know that flame was extinguished in the compound. Police exhumed the art and in presence of learned magistrate, and I noticed some bones beneath the art. I came to know that the dead body, which was cremated in the house compound of the accused, belonged to his wife. I came to know from the villagers the accused had murdered his wife. Thereafter, cremated her body in the compound. At that time, I also noticed the accused persons only Sri Gulab Gogoi and Sri Gonoram Gogoi in the house of the accused Sri Bijit Shrikia. Police seized some bones from the house compound of accused by serial list. Exhibit 4, one is my signature. The house of the accused is situated about 15 kilometers away from the police station. So his evidence is only regarding seizure. Other is hearsay about hearing. I came to know from the villagers, etc. The accused as murder. These are hearsay. Only seizure. Now his seizure is exhibit 4. By exhibit 4, residue of ashes were seized. Exhibit 4 is at page 89. Page 89, exhibit 4, page 90, serial number 1, residue of ashes of some burnt bones. Now, these were sent for forensic question. PW 11. Sorry, PW, sorry. Huh? PW 10, sorry, PW 10. PW 10, who examined the biology test of these ashes. PW 10 is page 30. He says, on 18/7/2014, I was serving as a junior scientific officer, biology division, Directorate of Forensic Science, Assam. On that day, some articles were sent to the in charge. Yes, in charge Serology Division, Directorate of Forensic Science, Assam, with reference to Moriani PS case number such and such. Same was entered in our office as biology case number such and such. Description of the exhibits. One brown colored envelope containing few pieces of small burnt bone and bone ash along with charcoal. The same was marked by me as Bio 2605. Result of examination. Osteological and morphological examination of the exhibit number Bio 2605 marked by me reveals that these are few pieces of completely burnt bone of human in origin. However, determination of sex is inconclusive due to insufficient material exhibits. So, sex could not be determined. It is a male or female burnt ashes. Then PW 5. page 19. I know accused persons, namely Sri Gulab Gogoi and Sri Gonaram Borua, who are present in the chamber of the court today. I also know accused Sri Bijit Shekia, who is my brother-in-law. This is Dipali Shekia, who was the wife of accused Sri Bijit Shekia. The incident occurred about 3 years back. On the relevant day, I was present at my workplace. In the night, police arrived at my house and thereafter took me towards the house of accused. I noticed smoke in the house compound of accused. I came to know from the nearby people that the wife of accused had been cremated in the house compound by accused Sri Bijit Shekia. I do not know anything about the incident. Police directed me to dig the earth of the house compound of accused, and when I dug the earth, I noticed bones of human being beneath the earth. I dig the earth on the next day of incident. I found accused Sri Bijit Shekia in his residence along with police. I did not question the accused about the incident. I was produced before the learned magistrate for recording of my statement. Exhibit 5 is my statement and Exhibit 5.1 is my signature. Police seized the bones of human being by seizure list. Number Exhibit 4. Police also seized one dao from the upper side of the tin of the house of accused by seizure list. Exhibit 6. Wherein Exhibit 6.1 is my signature. The accused also put his signature as Exhibit 6.2. Material Exhibit 1 is the said seized dao. Police also seized one sporting which was worn by the accused at the time of incident being stained with blood, and one long pen white seizure list, Exhibit 7. But in Exhibit 7 was my signature. The accused was also present at the time of seizure and he put his signature as Exhibit 7/2. Material Exhibit 2 is the seized wearing apparels. On behalf of the cross-examination, I do not know anything about the incident. It is a fact that I did not state before the police that I was directed by police to accompany them to the house of accused, and thereafter, as per direction of police, I dug the earth of the house compound of accused Sri Bijit Shekia and thereafter noticed some bones of human being beneath the earth. I do not know those wearing apparels, whose wearing apparels police had seized from the house of the accused Bijit Shekia. Now, I beg to point out one thing in his chief lordship, in the last paragraph. He says, police also seized one sporting which was owned by the accused at the time of incident being stained with blood. Now, this is a unprobable deposition from this witness. He says in cross-examination, he does not know anything about the incident, whose wearing apparels police had seized from the house, and during seizure, he says that it was owned by the police at the time of incident. So, this part of the evidence needs to be discarded, lordship. Now, his Exhibit 4 already I have pointed out to the biological test. Exhibit 5 is 164. Statement. Exhibit 6, lordship, is page 94. It is a dao was seized, and dao was seized from upper side of a tin. Is page 94. It's page 95 is a description. One meat dao knife. This is about 17 inches in length, including the handle. The handle is of iron and there is a hole in it. There is no mention of what is a blast tint or etc. That is nothing. Now, it was also subjected to serological test. Exhibit PW8. PW8 by PW8. Page 26. On 7/7/2014, I was working as scientific officer, serology division, director of forensic science, Assam, Kailipura, Guwahati. On that day, I received one sealed parcel from the director of forensic science, Kailipura, Guwahati, Assam, in connection with Moriani case number, for instance, which was sent by the SDPO Titabar, Jorhat, by his memo number such instance dated 5/7/2014. The parcel was found in one sealed cloth covered carton box. On opening the parcel, it consisted of 4 exhibits enclosed with a cloth cover, which was sealed with the impression of seal corresponding with the seal impression forwarded. Description of articles. 1. Few pieces of half-burnt bones with ashes and charcoal marked as A, which was marked by me as 03361A. 1 cream-colored long pant said to be trouser contains 10 suspected blood mark as B, which was marked by me as 03361B. 1 yellow-colored sporting contains stain of suspected blood mark as B, which was marked by B as 03361C. And 4, 1 iron handle dowel contains stain of suspected blood, which was marked as C and marked by me as 03361. Now, before go to result of examination, Lordship, 4. In the CGR, there is no mention of any blood stain. Here he received a blood stain. Contains handle dowel contains stain of suspected blood, which was marked as C. This is important. There is some discrepancy. Now his examination result, it is 3361D. Lordship will find 3361D is serial number 2. Exhibit number 3361D gave negative test for human blood. Whereas his 3361B and 3361C, B and C are these wearing apparels. These were found positive test for human blood of group B. Now here, first, thou does not, or the thou has not been proved to be contain any human blood. Secondly, he is wearing apparels, though it gives a positive test of human blood of group B. There is no evidence as to the whether the accused person's blood is also group B. Number 1. Secondly, in cross-examination, it has been demolished that it belongs to the accused also. So these thou and wearing apparels cannot be connected with the accused person. The PW7, she turned hostile. Page 23, Onima Soikia.
Mother,
Yes, mother. I know all the accused persons, namely Sri Bijit Soikia, Sri Gulab Gogoi, and Sri Gunaram Borwa, who are present in the dock of the court today. Accused Sri Bijit Soikia is my son. The other 2 accused persons are my neighbors. This is Dipali Soikia, was my daughter-in-law. My son married Dipali Kaur about 12 years back. Out of their wedlock, 2 male child was born to them. Accused Bijit Soikia is also known as Kang. I reside separately from my son after their marriage. The incident occurred about 2 years back. I do not know the behavior of my daughter-in-law. I only know that my daughter-in-law used to consume alcohol every day. My son Bijit Soikia is used to come out of his house and for his daily works. I do not know anything about the incident. On the date of incident, I noticed my daughter-in-law hanging on a tree. I was produced before the magistrate for recording my statement under Section 164 CRPC. I gave thumb impression on my statement, which was recorded by the magistrate. Police had examined me. The witness was declared hostile. Now in hostile part. I have come to the court on receipt of summons. Police recorded my statement. It is not a fact that I stated before police. Now, before I referring to that, I beg to point out another thing. When 164 statements are recorded, It has a higher value than a 161 statement. That should be one. The moment 164 statements are recorded, the 161 should be discarded. Any contradiction has to be brought in reference to the 164 is declared. But here 164 has not been brought, 161.
Yeah.
Police recorded my statement. It is not a fact that I stated before police that my son Vijay Saikia, accused, used to quarrel with his wife regularly, that on relevant day in the morning hours, I heard quarrel in the house of my son, that after assaulting his wife, my son hanged her on a tree with a view that it was a case of hanging. The two sons of my son Vijay Saikia noticed the incident of assault and hanging, and they informed me about the incident. That with the help of villagers, he cremated the body of his wife. That to screen the offender, my son Vijay Saikia burned off the clothes of his wife. It is a fact that my son, with the help of villagers, had cremated his wife. I did not telephone to Gunaram Lahon, VDP president, about the incident. I also did not state before the police that Vijay Saikia had assaulted his wife with a dao and thereafter burnt her clothes. The prosecution bringing this. At present, accused Vijay Saikia is staying with me with his eldest son. It is not a fact that I have concealed the actual facts of occurrence. It is also not a fact that I have deposed falsely in the court today for the sake of accused. Now, there is a contradiction part has been brought, but these were not confronted with the IO. These have not helped. Firstly, there is a 164 statement. It has not been brought. Only referred that my statement is recorded. Contradiction to 164, if any, has not been brought. 161, contradiction to 161 has been brought, but that too has not been confronted with the IO. So these witnesses of no help for the prosecution. And in cross-examination, as page 25, she says that I did not witness the incident. I also do not know anything about the incident. Now, PW8, I have already referred. He is a seriologist. PW9. My humble submission is her evidence is important because she is not a hostile witness, what she says. It belies the prosecution's case now. She says, page 28, I know all the three accused persons. Incident took place before 2 years. They reside near my house. I knew the wife of accused Vijay Saikia. On the date of incident, while I was going for my duty, I noticed gathering of people near the house of Vijay Saikia. I went to his house. I noticed Dipali Saikia sleeping in bed. I noticed his two sons and accused Vijay Saikia there. I did not see any injury or blood. She was wearing her dress. I touched her hand and noticed that she was not, I think, taking that. She was dead by this time. I did not see, I think, other two accused. The dead body was cremated in the courtyard of accused Vijay. The other two accused who were present today are Gulab Gogoi and Gunaram Borwa. I asked the husband to the deceased about the cause of death. He replied that he doesn't know. The deceased was not taken to hospital. She was cremated before police arrived there. Distance of accused is at slight distance from my home. I don't know about the affairs of the house of accused persons. Cross-examination. I was not present at the time of cremation of deceased. I can't say who were present at the time of cremation. It is not a fact that I did not sit with the police. I asked accused Vijay Saikia about the cause of death, and he replied that he did not know. So this is the only witness who says there was no blood, there was no mark of injury. Only thing,
Who is this witness?
PW, she is an Asha Kormi of the village. Moriani
Asha.
Asha Kormi. Of the same village. Only things that that body was cremated as per her in the courtyard. Now PW10 also I have also referred. Now PW11, He examined the accused persons after his arrest. He did not find any injury mark. Clinically significant wound found, no clinically significant wound found on the body of the accused at the time of medical examination. PW12 is the circle officer in whose presence Exhibit 4 seizure list was prepared. Now PW13, Monu Bhuya, he was also declared hostile. I know the accused persons who are present in the dock of court today. They are Vijay Shrika and two others. The house of accused Vijay Shrika is near my house. Wife of Vijay Shrika died about 2-3 years ago. On the date of incident, I went to Namgarh for some religious function, puja. I returned from Namgarh at about 10 p.m. On the next day, I heard that wife of Vijay Shrika died. I came to know, witness took a long time to reply the questions of learned people here. I came to know that the dead body of wife of Vijay Shrika was cremated in the house of Vijay Shrika, who is also known as Ken. The house of Vijay Shrika is about a distance of 15 to 20 feet from my house. His house is on the other side of the road and my house is on the opposite side. Witness is unwilling to answer a question of learned PP. At this stage, witness is declared hostile by the learned PP juror. Now, I stated before the police that my name is Monu Bhuya. I am aged 57 years. On last 1/7/2014, came to know that wife of Vijay Shrika has died and that he cremated his wife in his campus. Sri Gulab Gogoi, Sri Gunaram Borua, where the officials of BDP were also present there, Ken lives near my house and he often assaults his wife. The cross-examination. I do not know how the wife of accused Vijay Shrika died. I cannot say as to whether the deceased wife of accused was cremated. I came back at 10 p.m. on the date of incident to my home. I do not know anything about the incident. I did not indulge in any discussions about the accused person. I cannot say what happened after the incident. I was not present at the time of discussion about the cremation of dead body of the wife accused Vijay Shrika. I cannot say who were present at that time. Now, from these witnesses also, I think there is nothing for the prosecution to take any advantage of this because he turned hostile, and in the hostile part also there is nothing. Only that the body was cremated in the campus. Now, PW14. Page 36. Sabiram Borua. I know all the accused persons who were present in dock of court today. They are Bijit Shrika, Gulab Gogoi, and Gunaram Borua. Except accused Bijit Shrika, other two accused were members of BDP. Accused Bijit Shrika is also known as Ken. The house of Bijit Shrika is near my house. I knew the wife of accused Bijit Shrika. I do not know the name of deceased, but I remember her face. The wife of the accused died about 3-4 years back. The distance of my house and Bijit Shrika is about 500 meters. I was not present at my house at the time of incident. I came to know from the villagers that wife of Bijit Shrika died about 12 p.m. on the date of incident. I came to know about the incident from the people of lying village. I did not go to the house where the deceased died. Both the accused persons, namely Gulab Gogoi and Gunaram Borua, are my related brothers. At the time of incident, they were officials of BDP. She was cremated in the courtyard of Vijay Shrika. I am an undergraduate. I did not inquire as to why deceased died. There is one house in between accused Vijay Shrika and my house. I heard that after the death, both the accused persons, namely Gulab Shrika and Gunaram Borua, went to the house of Vijay Shrika. After about 4-5 days, police came to the house of Vijay Shrika, attended the cremation of the deceased at the house of the accused. I came to know that the police arrested Vijay Shrika at night. The other two accused were arrested after 2 years. At this stage, the witness is declared hostile by the learned PP. I stated before police that on 1/9/2014, the dead body of wife of CBG Shikia was cremated on the courtyard of CBG Shikia. I also attended the cremation. Now, in his chief also, he stated he attended the cremation. Now, why he has been declared hostile? Anyway, he has attended the cremation. I cannot say as to why the wife of Bijit Shikia died. I did not see the incident myself. I cannot say as to what happened after the deceased died. I have deposed after hearing the same from other people. I do not have any personal knowledge about the incident. So everything goes hearsay. Only he attended the cremation. Now, IO, page 38. It states on 2/7/2014, I was working at Moriani Police Station as attached officer of police. On that day, the then officer in charge of Moriani Police Station, named Sri Jugal Kalita, received one HR from Raman Gogoi and registered a case and directed me to investigate the case. Exhibit 1-2 is the signature with endorsement of the then officers in charge of Moriani Police Station, which I know. I interrogated the complaint and I went to the police of incident. On reaching the place of incident, I came to know that the dead body of the wife of Bijit Gogoi was already been cremated. I went to the place of incident on 2/7/2014 at Lahingao of Mariani. I recorded the statement of all witnesses of this case. I seized some remaining part of the dead body, such as bones, clothes, etc. after digging it out from the cremation place. Exhibit 4 is the seized parts of the dead body, and Exhibit 4-3 is my signature. I seized one meat dao as shown by the informant Bijit Shikia from his house. Exhibit 6 is the seizure list of meat dao, and Exhibit 6-1 is my signature. I seized one long pant of sporting of the accused. Exhibit 7 is the seizure list. Exhibit 7-3 is my signature, the sketch map, and Exhibit 12-1 is my signature. I also seized one document containing signature of public. Exhibit 13 is the said document. Exhibit 13 is my signature. 13-1 is my signature. I also seized one Sony camera and one DVD. Exhibit 2 is the seized articles, and Exhibit 2-1 is my signature. Material Exhibit 1 is the DAO, as well as Material Exhibit 2 is the clothes of the accused, which is available at the court today. Thereafter, I sent the seized articles to the forensic laboratory. I recorded the statement of all the witnesses of this case and arrested the accused persons. Accused Gulab Gogoi and Gunaram Borua were arrested for causing harm to the evidence in this case. I also sent the witnesses Ritul Soikia, Anamika Soikia, Babul Soikia, and Ratul Soikia to the court for recording their statement. I submitted charge sheet against the accused under section 302(120)B of IPC. For example, it is not a fact that I have submitted false charge sheet. It is not a fact the accused persons did not try to cause disappearance to the evidence in this case. It is not a fact that the public did not give any consent letter for cremation of the deceased. It is not a fact that Bijit Shikia did not show any dao and brought it out. I did not send the seized dao to forensic laboratory for examination. Later on, he says that he sent the dao for forensic examination. Now, yeah, one thing is important from his evidence. He says that dao was seized as shown by the Bijit Shikia from his house. Now, PW witness to, because the Lana trial court tried to give it a color of section 27 of Evidence Act. There is no disclosure statement. Without disclosure statement, section 27 evidence cannot be invoked. PW, this evidence witness to this seizure is PW 5 and PW. This is 6, PW 5. Now, PW 5 says, PW 5 does not say that it was shown by the accused. As page 20. Police also seized one dao from the upper side of the tin of the house of the accused by its seizure list. Now, I will try to improve it. After lordship, P13 was recorded and ultimately, finally, judgment was delivered. Accused appellant has been convicted for life, rigorous and sentenced to rigorous imprisonment for life with fine of rupees 10,000. In default payment of fine to undergo rigorous imprisonment of another 6 months under section 302 IPC. Furthermore, the accused Bijit Shikya Khan is sentenced to undergo rigorous imprisonment 4 years with fine, and in default a further period of 3 months and rigorous imprisonment under section 201 IPC. Both the sentence shall run concurrently, and other accused persons have been given benefit of doubt. Now, the law point involves lordship, it is 164 statement, child witness leading to discovery. First lordship 164 CIPC. Please do. There are few decisions in 2023. I could not, I will take another day for this summation of those decisions, and if your lordships permit. This is 1972 3 SCC 280. Paragraph 8, lordship. A statement under section 164 of the Code of Criminal Procedure is not substantive evidence. It can be used to corroborate the statement of the witness. It can be used to contradict the witness. The first information report was considered by the session judge. Any special consideration of the, so this much is sufficient. It can be used to contradict the witness, or it can be used as a corroborate a witness. It is not a substantive piece of evidence. So in this case, once the statements made in the 164 statement has not been brought in evidence, only exhibited. 164 statement is exhibited. It is not a substantive piece of evidence. So mere exhibiting the entire contents does not come on record. It has to be deposed before the court. It is to be deposed before the court. There is no such deposition. But the learned trial court reduced everything from the 164 statement, and thereafter tried to take corroboration. This is not permissible because prosecution has not done it. This is a lacuna on the part of prosecution. It cannot be filled up by the learned trial court. Now, Lordship may kindly come to judgment, Lordship, page 71, 7. Page, paragraph 28, we can. Trial court tried to give it a implication of section 27 of Evidence Act leading to discovery. Paragraph 28, page 70. In the instant case, paragraph 28. In the instant case, the accused Vijit Shaikia alias Can made the disclosure statement in presence of witness Sri Mangal Gorai. There is no disclosure statement. Mangal Gorai did not say that there is a disclosure statement. IO did not say there is a disclosure statement. PW4 and led police to the house, to his accused to his house compound where he had cremated the dead body with the help of co-accused Gulab Gogoi and Gunaram Borua. Aforesaid witness further deposed in his evidence that he noticed co-accused in the house compound of accused Vijit Shaikia and Can. This piece of evidence gets full corroboration from the evidence of Sri Monu Bhuiya PW13, Sri Sabiram Borua PW14. No one but the accused had the knowledge of the cremation of his wife, Dipali Shaikia, after assaulting her. And as such, the information received from the accused being in police custody, leading to discovery of the bones, and assess his deceased wife, Dipali Shaikia, is admissible in evidence under section 27 of the Evidence Act. Number one, there is no disclosure statement. Number two, PW4 or PW is PW5 did not say that there was a disclosure statement. IO did not say disclosure statement. Only he stated the Vijay Shaikia led, and PW4 and 6, 5 also did not say that Vijay Shaikia led. He accompanied. They took them. He went there. He did not point out that there is the dao. It was recovered from a tin. So, the law regarding Section 27 Evidence Act has not been fulfilled. Requirement of Section 27 Evidence Act has not been fulfilled.
So this not regard the Dow,
Dao.
regard to the body, dead body. Disclosure,
Exhibit 4.
para 28.
Oh, yes. Exhibit 4, yes. Cremated the dead body with the help of cooking. Yes, there is, but there is no disclosure statement. There is no disclosure statement that it cannot be. It was whatever seized is seized. Exhibit by the Exhibit 4 SS as a seal, but it is not leading. It is not leading. And mere leading, even if it is leading, the single sole evidence of section leading is not enough. My humble submission, it is not leading because there is no disclosure statement, nor there the witnesses did not say that he led or he pointed out anything.
He pointed on, I have checked the case.
IO says,
I have original case that I have checked. As
It
pointed
cannot
out
be.
by the
In-
lordship, by the accused person. The Dow was. written.
these have not been proved. In a criminal jurisprudence court of law, it has to be deposed before the court. From the case data, you can, what is in the evidence, what is in exhibited, that is the those are the only materials which has to be considered, not the case diaries.
Lordship, in general course, lordship will not see the case diary, but we have found lots of cases where for reasons unknown, IO do not disclose the actual fact. Or if the witnesses depose, their statements are there, they say they be deposed before the court, the statement is not there. So in the event of the matter, if your lordship, you can lordship peruse the case diary.
This is a failure of the
Case diary under
prosecution.
172 for aiding your lordship, it may be looked in.
Then I-
CRPC.
Then I shall have to submit some authority on this point also. These are not permissible. These are not permissible. Now,
IOs do not follow the lordship stipulations. They have to show to the, to the witnesses, they have to mark it, my lord. As part as does in judgment, my lord, constitutional bench. They have to show it to the, to the witnesses, my lord, whether they have deposed before the court or not. It should be contradiction, how it should be made. There's a judgment of this honorable court also recent, 2 years back, no? I'll give the citation to you.
I'm sorry, Lordship, one by one I am submitting. These are regarding circumstantial evidence and as well as section 27 evidence. Separate for us. The first lordship 2011 SCC 724 Mustaqim. Paragraph 23 on it. May I please read? Paragraph 23. It is too well settled in law that where the case rests squarely on circumstantial evidence, the inference of guilt can be justified only when all the incriminating facts and circumstances are found to be incompatible with the innocence of accused or the guilt of any other person. No doubt it is true that the conviction can be based solely on circumstantial evidence, but it should be decided on the touchstone of law relating to circumstantial evidence, which has been well settled by law by this court. 24. In a most celebrated case of this court in Riddhi Chand Sarda versus State of Maharashtra, in para 153, some cardinal principles regarding the appreciation of circumstantial evidence have been postulated. Whenever the case is based on circumstantial evidence, the following features are required to be complied with. It would be beneficial to repeat the same salient features once again, which is under the circumstances from which the conclusion of guilt is to be drawn must or should be, and not merely may be, fully established. The facts so established should be consistent only with the hypothesis of the guilt of the accused. That is to say, they should not be explainable on any other hypothesis except that the accused is guilty. 3. The circumstances should be of a conclusive nature and tendency. 4. They should exclude every possible hypothesis except the one to be proved. And 5. There must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused. 25. With regard to section 27 of the act, what is important is discovery of the material object at the disclosure of the accused. But such disclosure alone would not automatically lead to the conclusion that the offense was also committed by the accused. In fact, thereafter, burden lies on the prosecution to establish a close link between discovery of material object and its use in the commission of the offense. What is admissible under section 27 of the act is the information leading to discovery and not any opinion formed on it by the prosecution. 26. Lordship, if the recovery memos were prepared at the police station itself, It is, though it is not applicable in this one. So, then Lordship, next one, 2010 6 SCC 525. It is on discovery only. Paragraph 20.
Yes.
For effecting a discovery, paragraph 20, for effecting a discovery, a statement has to be recorded on the part of the accused showing his readiness to produce material object, and it is only the part of the statement which is not incriminating and leads to discovery which becomes admissible. The evidence of this witness does not inspire confidence, and it is of no use, more particularly because the so-called, no, it is on the facts. So first 4 line, there must be a disclosure statement or discovery statement. Statement has to be recorded on the part of the accused showing his readiness to produce the material object, and it is only that part of the statement which is not intimidating and leads to discovery which becomes admissible. Now, in this case, Lordship, discovered ashes of burnt bones. It's sex is not, would not be determined. It is a female, because here is the allegation that one female has been killed. Now, murder, if there is no evidence of murder or killing, PW 3 and 6, child witness, either if their witness evidence has to be taken into consideration, what they depose before the court has to be considered, and it is in favor of the accused. And it has to be discarded totally. 3 and 6 goes. And there are PW 9. PW 9 says she visited, seeing there is a crowd, she visited, and she found their mother, wife of Bijay Shekhar, is lying in the bed. She already died. There was no injury mark, etc. Unless murder is proved, and it should be always in beyond reasonable doubt or beyond all reasonable doubt. One on suspicion, it cannot be. So, as it has been specifically stated in that case, Lordship, Mustaqin or Sharachandra Bidri, the circumstances from which the conclusion of guilt is to be drawn must or should be, not merely maybe. For convicting 302 has to come fully proved. Intention has to be proved. That she has been murdered has to be proved. There is no evidence. There was evidence 3 and 6, not evidence in their 164 statement, but these were not brought on record on evidence. What they stated before the court is in favor of the convicted appellant. In Dow, there was no human blood was found. Serologist report, in Dow, there was no blood was found. So all the circumstances, if prosecution is to prove all the circumstances against the accused persons. Now here, these are against the prosecution. Now, as Lordship, learned public prosecutor has submitted that there is the case study, these were not proved in the case. This is to be proved in the case. There should be in a 313 statement is to be put in the question that this is the disclosure statement. What do you say? From the case diary in the appellate stage, it cannot be considered. Your Lordship, I am submitting one decision on child witness. Although in that case it was convicted, but how a child witness was to be dealt with, it is there. Because in this case, the evidence of child witness is in our favor. Then 812 SCC 565. Nivruti Pandurango. Paragraph 9 onwards, Lordship, we apply. Age of the witness during examination was taken to be about 12 years. Then, since the Evidence Act 1872, in short, the Evidence Act does not prescribe any particular age as a determinative factor to treat a witness to be a competent one. On the contrary, Section 118 of Evidence Act envisages that all persons shall be competent to testify unless the court considers that they are prevented from understanding the question put to them or from giving rational answers to these questions. Because of tender years, extreme old age, disease, whether of mind or any other cause of the same kind, a child of tender age can be allowed to testify if he has intellectual capacity to understand questions and give rational answers thereto. This position was concisely stated by Brewer, Justice in Wheeler versus United States. The evidence of a child witness is not required to be rejected per se, but the court, as a rule of prudence, considers such evidence with close scrutiny and only on being convinced about the quality thereof and reliability can record conviction based thereon. In Dr. Ramarao Shakhare versus State of Maharashtra, it was held as follows. A child witness, if found competent to depose to the facts and reliable one, such evidence could be the basis of conviction. In other words, even in the absence of oath, the evidence of a child witness can be considered under Section 118 of Evidence Act, provided that such witness is able to understand the questions and also to give rational answers thereof. The evidence of a child witness or credibility thereof would depend upon the circumstances of each case. The only precaution which the court should bear in mind while assessing the evidence of a child witness is that the witness must be a reliable one and his or demeanor must be likely any other competent witness, and there is no likelihood of being tutored. The decision on the question whether child witness has sufficient intelligence primarily rests with the trial judge who notices his manners, his apparent possession or lack of intelligence, and the said judge may resort to any examination which will tend to disclose his capacity and intelligence as well as his understanding of the obligation of an oath. The decision of the trial court may, however, be disturbed by the higher court if from what is preserved in the records it is clear that his conclusion was erroneous. This precaution is necessary because child witnesses are amenable to tutoring and often live in a world of make-believe. Though it is an established principle that child witnesses are dangerous witnesses as they are pliable and liable to be influenced easily, shaped and molded, but it is also an accepted norm that if after careful scrutiny of their evidence, the court comes to the conclusion that there is an impress of truth in it, there is no obstacle in any way accepting the evidence of a child witness. The above position was highlighted in Ramashish Taluk Bhai Nayak State versus looked at it from the angle. Lordship, if Lordships believe that these child witnesses were tutored, then their evidence before the court goes. It cannot be considered. So at the same time, his 164 statement cannot go. So these three, PW 3 and 6 would be also not of any advantage for the prosecution, neither for the prosecution, not for the defense. On the contrary, the learned trial court put some questions to them, were satisfied that they are able to understand the questions and recorded their evidence, and they have not been declared hostile. Even then, with fairness, because I am appearing as an amicus here, I would submit that it is from this principle, it will be always better to leave aside their evidence, because they were living with their father, who is the accused in their case. So there may be a probability of tutor, etc. So their evidence goes away. 3 and 6 would be not beneficial for anyone. Yeah. Other than this, there is no other witness for the prosecution that there was a murder. It is to be proved there was a murder. Recovery or seizure says that something was cremated, but it could not be linked with a female body. It could not be linked with the blood of a deceased or blood of the accused in the apparels. There is absence of everything here. Not a single circumstance is linked, except they went to their house from the courtyard, recovered something. And of course, cremation, if is there, now in the village area, cremation is done. In the courtyard also, if anyone has a land, courtyard also it is done. Now, unless murder is proved, the mere cremation does not constitute any offense. Mere cremation does not constitute any offense. Even for bringing 201, it says causing disappearance of evidence of offense or giving false information to screen offender. Whoever, knowing or having reason to believe that an offense is committed, causes any evidence of the commission of the offense to disappear with the intention of screening the offender from legal punishment, or with that intention gives any information respecting the offense which he knows or believes to be false. Now there are 3 categories. What would be the punishment? No, there should be a belief that the offense has been committed. The other 2 co-accused persons who have been acquitted, they were the BDP members. They could have been the better witness. If there is a murder, they could have been the better witness. Now, they were the BDP member responsible. If there is anything, they would have informed to the police that there was something fishy, that cremation could not be done. So murder, elements or ingredients of murder in this evidence, total in the prosecution evidence is absent. Now, only thing that the cremation of a wife was done, now it creates suspicion. Whether it is also a subtle law that mere on suspicions, howsoever strong it is, it cannot take the place of conclusive proof to convict one person or beyond that is cannot be satisfied the standard of proof of beyond reasonable doubt. Ship now. That mere suspicion, howsoever strong, cannot take the place. Paragraph 8, Lordship. Realities of truth. Paragraph 8, Lordship.
Yes.
Realities or truth apart, the fundamental and basic presumption in the administration of criminal law and justice delivery system is the innocence of the alleged accused until the charges are proved beyond reasonable doubt on the basis of clear, cogent, credible, and unimpeachable evidence. The question of indicating or punishing an accused does not arise, merely carried away by the heinous nature of the crime or the gruesome manner in which it was found to have been committed. Mere suspicion, however strong or probable it may be, is no effective substitute for the legal proof required to substantiate the charge of commission of a crime, and the graver the charge is, greater should be the standard of proof required. Courts dealing with criminal cases at least should constantly remember that there is a long mental distance between may be true and must be true. This basic and golden rule only helps to maintain the vital distinction between conjectures and sure conclusions to be arrived at on the touchstone of a dispassionate judicial scrutiny based upon its complete and comprehensive apprehension of all features of the case as well as quality and credibility of the evidence brought on record. The quality of evidence brought on record, Lordship, it does not require any confidence. No, I have submitted another decision, Lordship. This is also that there should not be moral conviction. Lordship is aware.
2003.
2003, Lordship, paragraph 27. Similar. Before we conclude, we must place on record the fact that we are not unaware of the degree of agony and frustration that may be caused to the society in general and the families of the victims in particular by the fact that a heinous crime like this goes unpunished. But then the law does not permit the courts to punish the accused on the basis of moral conviction or on suspicion alone. The burden of proof in a criminal trial never shifts, and it is always the burden of the prosecution to prove its case beyond reasonable doubt on the basis of acceptable evidence. In similar circumstances, this court, in the case of Sarwan Singh, Ratan Singh v. State of Punjab, stated thus: "It is no doubt a matter of regret that a foul, cold-blooded, and cruel murder should go unpunished. There may also be an element of truth in the prosecution story against the accused. Considered as a whole, the prosecution story may be true, but between may be true and must be true, there is inevitably a long distance to travel, and the whole of this distance must be covered by the prosecution by legal, reliable, and unimpeachable evidence before an accused can be convicted." 28. It is also a subtle principle of criminal jurisprudence that the more serious the offense, the stricter the degree of proof, since a higher degree of assurance is required to convict the accused. So my humble submission in the instant case, prosecution has miserably failed to prove the case beyond reasonable doubt as per law. In a court of law, the only legal proof is matters. This much and you
You wanted to place some more judgment?
Yes, 20 judgment, 2-3 judgment is there, but I could not bring it up.
Let him finish his part. Monday,
Tuesday?
Tuesday,
Tuesday.
Lordship, then I'll make my submission.
He will also have sufficient time. Tuesday.
Only problem is whether this bench will continue.
Lordship, as per the cause list, this bench is available in the coming week. Advanced list is there.
I'm not aware.
This come up yesterday.
Anyway. Heard Mr.
SD Purkast.
S.T. Purkayastan and I'm the security. Also heard MS B. Buyan and addition. Heard him. This for 30 minutes again. You want it on Tuesday?
Plus
28.
20. 20?
28,
7. Monday.
28,
Monday.
Tuesday.
Oh, it's 23. Okay. So it is a 22. Yes. Obviously.
Julie.
Lordship, this is an application under section 389 for suspension. This is the second time which we have preferred it. Additional grounds on additional grounds.
New ground.
Yes, additional ground is, Lordship, the welfare of the child. The appellant, he has got a kid who is studying in the 10th standard, and the parents, they have separated during the course of the trial. The mother resides somewhere else. The custody of the child was with the accused, that is the present appellant. He is in a boarding school in Nagaland district, in the state of Nagaland. Don Bosco. He's in a 10th standard. He's in a very crucial phase of his young life, 10th standard, and now no doubt the paternal uncle is looking after the child. But still, suddenly the appellant was convicted and he was taken into custody. Now he has to arrange for funds also for maintenance of his child. These are the reasons, emergent reasons, Lordship, urgent reasons for which we are seeking suspension of the sentence, even if for some time. I mean, he has to settle his son for some time, arrange for funds for maintenance of his child, as well as considering the fact that he is in the 10th standard.
You don't have other relatives.
The paternal uncle is right now supervising the child. No doubt he is in the boarding school now. But problem is, Lordship, the father, the appellant, he was working, he is a businessman. He is working as a contractor with various government departments. And some substantial amount of bill payments are to be realized from these departments. Now, if you can, and like it is he who can pursue with the government departments and realize it, so that he can arrange for the funds and for the maintenance. Even the relatives who are in the paternal uncle, he is a small-time businessman who does not have much of resources. He has to maintain his own family also. So he has to provide for at least funds for handing over to his brother, that is the paternal uncle. These are some humanitarian considerations, Lordship. Lordship, the child cannot suffer because of what the parents have, because of his whatever his father may or may not have not done.
Conviction under
302. Life imprisonment, sentence of life imprisonment.
The pleadings that I see here, of course, whatever she said, is this, he was a contractor. He was supposed to get his contractor's money, and then he will pay for his child's 10th board exam. One maternal uncle is there, but he is also a very small, petty businessman. And then mother is no longer with the child. She left 7 years back. Those are there, but then only on humanitarian. Merit-wise, it was rejected once. We cannot enter into again. Here,
Merit-wise also probably your Lordship can enter, because one of the consideration,
That was already considered, isn't it?
Yes.
Yes,
Yeah.
yes, these consider Lordship and entirely on human. But Lordship, the child cannot suffer because of whatever his father may or may not have done. And the mother has left the child. Very, very unfortunate.
But the child is in the hostel.
He's in the hostel, but still 10th standard, he's under severe mental stress. Of course, the child has not been told informed regarding his father's state of affairs. What has happened to his father? That has not been informed.
He's a 10th student.
Yes, no, not. He'll be appearing for his board exams and all that. Lordship knows how it is with these teenage children nowadays.
One interim suspension can be given. Sometimes it is allowed for some personal reasons. For
At
a
least
fixed
Lordship, if
period.
we can pursue with the departments for realizing his bills, outstanding bills, and he can make the necessary arrangement for providing the necessary fund with his brother, that is the paternal uncle, who is presently looking after the child. And if for some time he can see his son and make him understand, these are the very, very humanitarian grounds, not only for the child, young kid.
Tinsukia. At best interim suspension for a week or so, he will surrender immediately.
Not even a week will not do.
No. 3 months.
Government or department of Zana bail ekidaka. Ini mama lagi. Bonson di mar.
His brother will pursue now.
Huh?
And then he'll come and sign this. For realization of bills and all, his brother can pursue and then he can sign it.
Those are not not good.
Not
For the
For
child
monetary.
welfare of the child.
Yes, only because of that.
No,
For
what
some time, Lordship, even if for some time.
his brother can pursue and then he will
No, that
finally
is
give
another
his
aspect,
signatures.
Lordship.
And then the money can be taken out, drawn.
It's a financial year, isn't it?
Yes,
Much.
Financial year is coming to an end.
yes, coming to an end.
But what
Course.
what can you do
No,
now?
even the school authorities, they have to be informed. He's the guardian. Suddenly, all of a sudden, he was taken into custody. Even the school authorities have not been informed. The child has not been informed. At least, Lordship, I'll be repeating my burdening your Lordship with repetition of my argument that the child has to be settled properly, at least for only for that. Even if for some time, sentences. At least he can inform the school authorities personally and also the child. That aspect, Lordship, will be taken into consideration. Even they are not objecting for some time, as an interim measure.
Maybe they may not object, but the court may not like to do.
No, I'm leaving it to you, Lordship, if you understand. Lordship, that aspect may be considered, only that.
Practically, you're getting your bill, chasing your files. These are not grounds.
No, Lordship, the child. Lordship will imagine how it is. None of his parents are there at this crucial juncture of his life.
Child is not a very small child. 10th standard, so
No.
he'll be around 16, 17 years.
That is the most, these years are the most crucial, crucial years of a child's life.
I don't have any
14,
information
15.
regarding this chapter, only whatever.
No, we have
learned
enclosed the
counsel
admit
is
card,
saying.
etc., where he's studying,
get
identity
also.
card of the child we have enclosed. Of course, he's in the boarding school. Even then, the father, at least if he can go to school and inform the authorities, the child, etc., he has not also been told, informed.
It's not in Dimapur.
Tuli. The identity card at page 45. Lordship, this is last year's ID card 9. He's at the 10th standard now.
18 doors, so 19, 20, 20, 24, 25, 14 years.
Any condition can be imposed, lordship bond, and can be taken lordship only for some time as an interim measure.
And married wise, the three ladies were together in the house of the deceased. And then the applicant's wife was also there. Applicant wife was making some tea. Then this applicant came. He went straight to the kitchen. They had a quarrel. Thereafter, he came out. He quarreled with the deceased as well. And then during the quarrel, these two other ladies came out of the house. After some time, when the applicant's wife went to take back her keys, she found the lady.
Last seen together, that was the only ground on which this appellant was convicted. Last seen together, and that too they have relied on a 164 statement. There are, and the learned court below itself observes that there are many lapses in the investigation and on the part of the prosecution. That is reflected in the trial court's order.
164 statement I'll not rely on, but the other
No, trial court
lady's
has
statement
relied.
is there.
Trial court had relied on the 164 statement. 164 statement is not admissible in evidence. That has been relied on. And the last in together, even that has to be correct, that needs corroboration. If your lordship grants me one opportunity, I can submit on these aspects also.
But that was already considered. No?
Yeah,
As it is, my learned friend is submitting on the merits aspect. That is why I'm submitting on this. Learned
Okay.
trial court itself, court below itself points out.
heard MSD for go ahead. Learned counsel for the applicants. Also heard Miss MS S. Jahan. Learned additional PP Assam. Appearing for the state oblique respondent number 1.
One.
Stop. Para. By the present I, which is filed under section
389.
389 within bracket 1 of the CRPC, comma, the applicant, who is the accused, convicted by the judgment and order dated 22/6/2022 and sentenced to undergo rigorous imprisonment for life with fine of ₹10,000 in default to undergo simple imprisonment for life under section 302 of the DMA. Is praying for suspension of sentence and for releasing him on bail. Learned counsel for the applicant. That the son of the applicant, who is aged about,
15 years.
who's aged
15,
about
2008, 2008 he was born. So no, not for 15, he's 14.
14.
aged
14.
about 14, is presently studying in
Class 10 standard.
class 10 standard at Don Bosco School, Tuli, Mokdum District, Nagaland. The wife of the applicant has also, they have divorced, no? has
No,
also-
they have
has-
separated. They have separated.
Simply
are
left. no?
separated. And the welfare of the child is is separated, and the child and his son, who is in hostel, requires some attention, particularly with regard to his peace, etc. So, therefore, considering the welfare of the child, learned applicant submits that the learned counsel for the applicant submits that interim suspension of bail, interim suspension of the sentence may be made and the applicant be released on bail. Stop. Para MS El Jahan, then addition to. On the other hand, submits that the applicant had earlier filed an IA, which was on this praying for suspension of sentence and release on bail, which was registered as IA within bracket criminal 486 of 2022, which was however rejected on
25th of January.
She submits that no new grounds has been taken, and therefore the present I deserves to be dismissed again. After hearing the parties, the consideration of methods available, we also see that the earlier I was dismissed on merits by this court, and the present IA has been filed only on the consideration for the welfare of the child of the applicant. What the next? Okay. Considering that the son of the petition applicant is a minor, aged about 14 years, and residing in the hostel of Don Bosco School, Tuli, Nagar, we accordingly suspend the sentence for a period of 2 weeks. Will do.
1 week.
1 month, can it be?
No. 2 weeks. You do whatever you can do within 2 weeks.
Lordship, between her and me, 3 weeks, Lordship.
I don't know.
Lordship, she says 1 week. I
She
say
can
1
come
month.
for
Let it
extension.
be in between that 3 weeks, Lordship.
She can come for.
Who is also approaching.
We're not giving any extension.
No, Lordship, who is also approaching. That is why, Lordship.
No,
Bihu.
You want to enjoy the bihu or
No,
you want
no,
to
no,
look into the welfare of the child?
Lordship, yes, Lordship, 2 weeks or 3 weeks, any.
2 weeks too.
For a period of 2 weeks.
And he'll surrender immediately on expiry.
Stop. Who is the in charge? The superintendent of jails?
Superintendent of Tinsukia district jail.
The superintendent of jails.
Superintendent of jail, school jail.
Tinsukia, is it?
Tinsukia, it should be Tinsukia. You Jana?
Tinsukia.
Is it a central jail
Tinsukia.
or?
No, district jail, I think.
Tinsukia.
Do you have any materials which we can direct?
No, the superintendent of police, Tinsukia can be directed. Superintendent of police, Tinsukia can be directed.
Jail, superintendent of jail has to be there.
Superintendent of jail, Tinsukia. Tinsukia.
So this is,
Yes, also judgment case.
yeah, otherwise his residence is at Tinsukia.
Lordship, it will be superintendent of jail, Tinsukia district jail. It has to be. No, send the cases.
Or I'll have to find out then by talking to the superintendent.
You inform us?
District jail,
Yes.
video conferencing herself, ito.
Is produced from, yes, page in the main appeal. There, on the hearing on the point of sentence, it's written that he is produced through video conferencing from district jail Tinsukia. It's in a main appeal, page 146. I mean, the memo of appeal.
You can't give me a
Lordship have got it, page number 146.
146.
One hearing on the point of sentence.
Oh.
Ujjwal Kumar is produced through video conferencing from district jail.
Yes, district jail.
District jail.
District jail, it's okay. Is directed to release the applicant on production of a certified true copy of the order of this court. From the date of production of a certified true copy of the order of this court for a period of 2 weeks from the date of release. Draft applicant shall surrender for the
He should not be allowed to go out and all. He cannot leave the jurisdiction of the court and all those
Yes,
conditions.
that can be imposed.
That can be imposed.
No, he'll go to Nagaland also, no? He'll have to go to Nagaland.
State to Nagaland.
It's fine.
Yes. With due information to
No,
the
We
station.
require one, what you call it?
Trans-
Surety, one surety.
surety.
Along with the surety.
Ah,
On
we're executing a bond.
executing a bond of rupees 25,000. Along with the surety of like amount. Who shall be a government servant.
Yes,
No,
government
not
servant or a
necessarily government
landholder.
servant.
I'm sure you'll have some friend.
Government servant, lordship, probably
That is the.
land, lordship, land
the best
documents.
Surety we can have.
Lordship, a person who has immovable property within the jurisdiction of the court in Tinsukia, that will also probably because person who has
You
immovable,
don't have friends, government servant.
lordship, that I'll not be able to answer unless and until I have. declared how finding.
Along with the surety of like amount. Who has immovable property. Within the jurisdiction. Of.
Tinsukia,
Of
sessions just,
of the sessions judge.
yes, Tinsukia.
Sessions judge.
Yes.
Tinsukia district.
Yeah.
Now. Should we give dates? No. When you'll get the production, I don't know. We'll get
Yes,
it.
yes, that,
Immediately on expiry of 2
2
I've
weeks.
already
yes,
Oh, yes.
got
from the
that.
date of release.
IAS
The date of-
allow. Allow is partially allowed.
Hope he doesn't flee.
Yes. We'll be going to another statement.
No, nothing. No, the child is there, where you left gone.
Yes.
Child is there, he's. Deeply obliged.
Make sure you come back.
Lordship. Lordship. He'll come back, he'll come back.
Lordship, I have
Lordship. He'll come
given two judgments on contradiction. One of Honorable Justice Suman Shyam and one of division bench of consisting of Honorable Suman Shyam, Your Lordship.
Which-
And one
which matter?
previous matter, I have given the citations. Your Lordship may have a look.
Item 30.
Parted matter.
Tuesday.
Not.
That will come up on Tuesday, no?
Not. Finish.
Obliged.
Itu fakta pala.